what's going on real quick.
Yeah.
Okay, so the purpose of my motion is that our basic premise is that the affidavit is supposed to be statements of fact, and then the court applies the law. This is a complex area of the law without a lot of precedent on it. And so what happened is the Attorney General supplied legal statements and legal conclusions as the bulk of the affidavit. The court and the reviewing magistrate relied upon those statements and applied the facts to those statements. Now, we believe that it is an issue of law, that there was material misrepresentations of the statements of the law as provided to the court at the time. And we want to review the legal issues, not the factual issues. We're accepting the facts as stated for purposes of this next matter, but we're saying that these do not constitute a crime. Specifically, the issue is the prosecution has cited repeatedly an argument that she has been charged with unlawful disclosure because of a transfer of information from the clerk to her attorney and from her attorney to her expert. It was not a public disclosure. She's not charged with disclosure. She's charged with other violations of law. And they're trying, in my opinion, to pound a square peg into a round hole. And I believe that we need to have the law reviewed and settled. Otherwise, it's going to be a waste of time. The law is going to determine the facts that need to be presented for the question. So a preliminary exam is a presentation of facts in a light most favorable to the prosecutor, and so is an affidavit. So now the next step for a preliminary exam, if we can get through the appellate process, is tentatively scheduled for the 12th and 13th of September. And what the process will be, just so you're aware, is that within 1 week I will file the appeal to the circuit court. The prosecution, the DA will, or the Attorney General will respond, and then the judge in circuit court will make a determination. We'll request oral arguments. There may or may not be. Subject to that ruling, there may or may not be the next level. The challenge is, and the judge was exactly right on the law on this, is if we do not raise this, we waive it. And that's the reason I'm sorry to inconvenience you, but this is an important issue to settle the law. And one of the challenges, if you've been following, the United States Supreme Court just issued a declaration in repealing the Chevron doctrine. The Chevron doctrine basically established that executive branch agencies could not only interpret the law and interpret and issue laws. And so when we, the people, delegated through a constitution to 3 branches of government, there's a separation of power. The legislative branch, which is our representation, is supposed to make substantive law. Agencies should not be making substantive law. They should be making procedural rules. And what happens is when they have the ability to have an unconstitutional grant of authority to issue whatever instructions that they want without following formal rulemaking process, you get into this situation where attorneys are trying to interpret by looking at the body of law. What does the legislature say? What are the published and promulgated rules? And then they're giving advice based upon what is in the body of law. And I've never in my life had to cite an email as authority. And that's what they're suggesting has to happen here. So thank you for your time.
Can I ask a question?
Brief.
All right. Has the expertise provided by Mr. Cotton been acknowledged as attorney-client privilege yet? And if
Yes.
it would, so does that not undercut most, if not all, of the arguments being made?
So let me be clear here. We're not hiding Ben Cotton. Okay, there's nothing that Ben Cotton did or that the clerk or the attorney in this matter did in relation to that. The problem is that an attorney has the ability to consult experts, and those experts are covered by attorney-client privilege. And what is covered by that privilege is they stand in the same shoes as an attorney. So in other words, if you tell your expert something, that's like telling your attorney something. And if you look at what a client to an attorney relationship is, you are in fact telling the client is now standing, when the client tells the attorney is like telling yourself. They stand in the shoes. And why the communications are privileged, okay, is because they're not talking about committing a crime. It is the communication of information for the purpose of review for a civil suit, which opposed, sorry about that, it opposed remember, I want you to be aware that the Secretary of State has been opposed previously in civil litigation by Clerk Scott and by Attorney Lambert. And so what happened in that opposition, they were preparing research and dealing with this issue to seek declaratory relief to clarify the law. And in that process, they were scrutinizing and studying information. And it is from that internal communication that they're saying was an unlawful transfer.
Right. So my question is, if that's already been acknowledged as privileged, what remains
You're going
as
to be in
evidence?
trouble, sir, but let me just say this. It's been acknowledged that it's privileged and under work product. However, the Attorney General, and my pleading will speak for itself, suggested that we agreed to the scope of that privilege. And he's suggesting that while it's privileged, there's an exception. I believe that is a material misstatement of what occurred between attorneys. And I've asked the court to basically, we've challenged the scope, because if you look at the grant of immunity, it says it is attorney-client work product. However, it comes in under this exception, which is a civil discovery exception. And he suggested that there was an agreement between the parties at the time the order was presented and the judge signed it. And I've asked the judge to rescind that order. So thank you guys, appreciate it. God bless you all.
Same to you.
Thank you.
God bless you.
Please.